Welcome once again to Lehto's Law. Here's Steve Lehto.
During COVID, we've heard a lot about trials being conducted via Zoom, hearings and trials and all kinds of stuff. And it raises some interesting constitutional issues that most people probably don't think about. So here's a story that Keith sent me from the Associated Press. Linda Whitehurst and Michael Tarm wrote it. Ruling raises new questions about remote testimony in court. Remote testimony in court. A case out of Missouri had a conviction overturned, and it's raising new questions about video testimony in criminal court cases nationwide. The ruling could have ripple effects for a justice system increasingly reliant on remote technology as it struggles with a backlog of cases during the coronavirus pandemic. Missouri's Supreme Court recently reversed conviction of Rodney Smith in a case from St. Louis, finding that an investigator's video testimony violated that man's right to confront the witnesses against him. That comes from the Sixth Amendment. We'll talk about that in a second. The investigator appeared remotely in 2019 because he was on paternity leave, and he testified that DNA evidence taken from the victim's clothing matched the defendant's DNA. It was a key point in the case. And meanwhile, the primary complaining witness against the man has recanted her accusations. So the conviction and the sentence hinge primarily on that DNA evidence. And if that testimony was disallowed, then the whole case falls apart. So a lot of states and federal courts have halted criminal trials for months during the pandemic, but they're also occasionally allowing remote trials when defendants explicitly agree to forfeit the rights they have to confront their accusers in person. So if you want to have your trial now and you're willing to waive that right, some courts will say you can go ahead and do that. Right about now, it's looking like if you were asked to waive your rights and you did, you may have screwed up a little bit. So the Missouri ruling differs from many pandemic-era cases because the judge went ahead despite the defendant's objections. So the defendant objected and said, I think that witness needs to come into court and testify. Judge said, I don't think so. We're going to let them testify via remote hookup. The state court systems typically handle millions of cases every year in total, the vast majority which will not be directly affected by the legal questions raised in this case. The number of trials also plummeted during the pandemic, so that means there's going to be a backlog. And even if that decision impacts only several hundred cases, it would mean yet more challenges for an already overburdened judiciary. Right about now, every defense attorney out there is telling their clients, look, we do not waive that. If they ask us to waive it, we won't. If they force us to go ahead, we're going to file an appeal on that ground. So the decision could eventually make this a test case for the U.S. Supreme Court, says a former Chief Justice of the Missouri Supreme Court and a professor at the St. Louis University School of Law. The guy was convicted with the use of Zoom technology and could not have been convicted without it. The nation's highest court has allowed exemptions for child witnesses to testify remotely to shield them from potentially traumatic experience, but you still don't get away from the fact that the Constitution says there's a right to confront the witnesses. The limited exception that they have granted, and I'm not going to get into the details of that, is in a case where the child victim would be forced to see the defendant that they're accusing of something in court. And so they've allowed there to be some things, some methods to keep that child from being directly confronted by the defendant. But even that is a touchy subject. So the U.S. Supreme Court's grappled with this for some time, though the constitutional questions it raises have never been fully answered. A landmark ruling in Maryland versus Craig back in 1990 upheld a trial judge's decision to let a victim of child abuse testify remotely. But it was a 5-4 decision. The court said the Sixth Amendment doesn't guarantee an absolute right to in-person confrontation, especially if remote testimony is necessary to further an important public interest. It's a lessening the trauma of testifying to a child was a compelling public interest. The dissenters in that case, the 4 of them, said the Constitution provided no wiggle room, and the point was to place the witness under the sometimes hostile glare of the defendant. Some of those same justices were in the majority 14 years later in Crawford versus Washington, which asserted that the right to confront an accuser in person was pretty much absolute. Really, really close. Not quite, but close to absolute. Recently, the Minnesota State Court of Appeals differed from the Missouri court by ruling that allowing a witness to testify via live, remote, two-way video did not violate a defendant's rights under the Sixth Amendment. During the pandemic, multiple trial-level state and federal courts have displayed care in not appearing to trample on the principle, which dates back to Roman times, believe it or not, that those accused of crimes that could cost them their freedom have a right to confront their accusers. In August, Kentucky's Court of Appeals upheld a lower court's decision denying a prosecutor's request to let one witness testify by video at a fraud trial from prison because traveling to court would put him and others at risk of COVID-19. The appeals court said general concerns about the spread of the virus do not justify abridging a defendant's right to in-person confrontation, and that prosecutors never proved the witness was particularly vulnerable to COVID-19. The fundamental question has been this: is a remote witness testifying by technology functionally the same as being there live? Asks Frederick Lederer, a chancellor professor of law and director of the Center for Legal and Court Technology at William & Mary. We don't know if this is constitutional at this point. Remote technology has helped drive down no-show rates in many areas by allowing people to attend even if they have to work or care for children, says David Slayton with the National Center for State Courts. So the real issue is this. The Sixth Amendment is one that people are not as familiar with, except that they've heard portions of this. They just, the fifth is, right to remain silent. The sixth is about trials. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. That's the first part, the speedy trial and the public trial, by an impartial jury of the state. So you have a right to a jury trial. And it says, and district wherein the same crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. They got to tell you what you're charged with. To be confronted with the witnesses against him, and then to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel. So the idea that you get an attorney comes from the sixth. Also, the idea that you can serve subpoenas and drag in witnesses also comes from the sixth. But here's the key. It says, to be confronted with the witnesses against him. And of course, that could be her. Confronted with the witnesses. And so the idea is often just shrunk down to you have the right to confront the witnesses. Confront the witnesses. And you can argue all day long about the many meanings of the word confront, but it's generally been accepted that that means that you get to face your accuser. And that's often also how it's phrased. You have the right to face your accuser. And most people, if you simply said, what does it mean to confront somebody or to face them in this setting? They'd say, oh, you've got the right to where if you are on trial, to make the witness come into court where you can see them and they can see you and testify. So we all know human nature is that there are people who will talk behind your back and say all kinds of crazy stuff. Put them on the stand in front of you, in front of a judge, make them swear to tell the truth. Now watch what happens. And more importantly, and this is the thing that I think that will possibly be the nail in Zoom's coffin when it comes to trials, is that courts will tell jurors in the jury instructions that they have the right to actually question a witness in their heads as to whether or not that witness is telling the truth. So in other words, witness gets on the stand, swears to tell the truth, and says, yes, I saw the defendant driving the getaway car. I saw the defendant driving the getaway car. A bunch of other witnesses come in, testify, all kinds of stuff. You go back into the jury room, and somebody goes, hey, there was a witness who said, I saw the defendant driving the getaway car. Boom, that's over, isn't it? You have the right to go, no, I didn't believe that person. I didn't believe them. I found them to not be credible. And they will tell you that when you are watching someone testify, that's the key word. You're not listening to them testify. You are watching them testify. And the reason that is that you can look at somebody and watch them testify. You're listening to what they say, but you're also watching how they behave. And we've all seen people who can say one thing and their body is saying the exact opposite. The exact opposite. And I've seen it before, where someone gets on the stand and testifies, they walk out of the room and everyone goes, I didn't believe that, did you? And the jurors didn't believe it either. The judge didn't believe it. Nobody believed it. But if you read the transcript, the person said, this happened. No one believed it. Now, reading the transcript, you'd go, well, they said this happened. No one believed it. Why? It wasn't the words coming out of their mouth. It's the way they were presenting themselves, their demeanor perhaps. And that could be their facial expression, their tone of voice. If they're up there shaking, if they're nervous, if they're stammering, there's all kinds of things that people can do that you can only see properly by looking at them in person. And the idea that someone is going to be possibly miles away on the other end of a computer screen, you can only see their face. And by the way, it's a bad connection. I don't care what you say. And they're going to testify. And they're testifying against you, the defendant. But here's the problem. The way Zoom works, half the time it's a little screen this big on your thing. Or if you have it set to where the person talking pops up, they pop up, and then someone else pops up. In court, you could sit there and watch them the whole time. So could the jury. The jury could watch them the whole time. And quite frankly, that to me is the most important part about the idea of confronting your witnesses. It's not that they got to come in and testify in front of you. That's part of it. That's part of it. And I think that most people would say that it's only fair that you get to face your accusers. But if a jury is deciding your fate based on the testimony of witnesses, those witnesses need to be dragged in front of them in person in a courtroom, and you need to let the jury watch that person testify. Everything about it. As they walk up the box, as they walk away from the witness box, as they sit in the witness box, how do they behave? How do they appear when they're testifying? What does it look like? And you cannot get that experience over Zoom. You can't. So I agree with this ruling that it is a problem to let witnesses testify via Zoom if the defendant objects. Now, if the defendant is asked, do you want to go ahead anyway? We got two witnesses appearing by Zoom. You can waive that if you want to. Defendants can waive their constitutional rights if they want to. They do it all the time. You can waive your Fifth Amendment right and testify if you want to. You shouldn't, but you can. But the point is that you can waive your Sixth Amendment right to a speedy trial, for instance. So I've seen it before where the parties come into court and the judge goes, are you guys ready to go to trial? And the defendant's attorney says, no, we're not, Your Honor. We got things we're working on. And the judge will look at them and say, you understand that if we give you an adjournment now, it's going to push your case further down the road. You might not be getting a speedy trial, which you're guaranteed under the Sixth Amendment. And if the defendant says, no, Your Honor, I've talked to my client about that, and he understands that's the trade-off here, we could go to trial now and get the speedy trial, or go to trial later better prepared in a non-speedy trial, and we've opted for that. And I've seen it before where a judge might actually ask the defendant, is that your understanding and that's what you want to do? Okay, fine. Now it's on the record they've waived that. So you can waive your right to confront your witnesses if you want to. But right now, I suspect many attorneys are advising their clients not to because of this recent ruling. So it's an interesting case. Modern technology often causes the Supreme Court to revisit issues. And 5 years ago, if you said, Steve, there's going to be a huge fight over whether witnesses can appear over some kind of internet hookup, I would have said, what? Why? But of course, no one saw COVID coming. So ruling raises new questions about remote testimony in court by the Associated Press. Lindsay Whitehurst and Michael Tarm wrote it. We'll have to wait and see what happens with this. Keith, Senate, thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. People who exercise their brains stay young in spirit.